Hello, everyone. Welcome to Jamaica 411. Thank you so much for joining me today. I'm your host, Michelle Stern. Well, Mark Goling. That man just cannot seem to get it right. Now, I know you must be wondering what it is I'm talking about. You remember the last press conference when they were speaking about a number of things. One of them, of course, including the MOU deal between the United States, the what we call a deportation deal. That is a third country national deportation deal, which is to enable the United States to enter into an agreement with Jamaica. That's what MOU is about. That will see these particular deportees, they will be persons who breached the United States immigration rules, whether them went there by crossing the border or they arrived in the United States on a visa, temporary visa, and overstayed, and they find themselves arrested by two agencies that operate under Homeland Security, either ICE or the Customs Border Control people. And then the United States is seeking now to send them back home, but for some reason, Donald Trump decided that he wanted to take this circuitous route through a third country. Now, remember, I explained in the last video I did on the same program. The very first agreement was signed between the United States and Canada, and it was to determine what's to be done with the asylum seekers who cross the border from Canada into the United States and from the United States into Canada. The agreement was wherever the people landed first, that is where they must seek their asylum. So that was the original agreement. It was an agreement to do with the border country of Canada. Then now the United States decided to expand the program, and they entered into what they call an asylum cooperative agreements with countries that are not bordering the United States. You understand? Yes, so that was the purpose why they had to enter into another agreement. So countries like St. Kitts and Nevis, which is in the Caribbean, Antigua and Barbuda, Belize, which is on the Central American mainland, I suppose. And then now you have the countries in Africa, such as South Sudan and Eswatini. They are part of this asylum cooperative agreements. And so what happens with this program is that the United States will accept the requests for asylum seekers, and they remain in the United States, and those that they reject are sent to these other countries that the US has this agreement with, and that country will more than likely accept the asylum seekers' request. And the reason for doing so is because of the Convention on Refugees that the US government signed. They cannot send these people back to the country where they say they fear persecution, except for when the application was rejected. So the solution was to send them to a third party country that would accept their request for refugee status there. Without this policy, the third country national agreement, these persons would have had to be sent back home. So it really was a humanitarian consideration why the United States set up these particular third country national agreement in the first place. So the arrangements is not what was being challenged in the Massachusetts courts. It was something else. But that is not the agreement that we will be entering into with the United States. The agreement we'll be entering into with the United States is one that will see the deportation of ordinary persons, persons who cross the border into the United States through Mexico, and those who came in by boats, and those persons who flew in, however, them reach into the United States. And then you have those who came to the United States legally on a temporary visa and overstayed. Those are the persons that will be arrested, processed, and instead of sending them straight to them yard, which is much cheaper for the United States, them decide to take the circuitous route. And of course, that's Trump's policy. And I can't see what reason there could be for the United States to take on this extra expense other than to punish the people, because it's going to cost them maybe three, four times what it would have cost them if they send them directly home. So that is what we are signing into. That is the background. So this video now is about the statement that was made by Mark Golding in his in the press conference, the last press conference that the PMP had, and he made a claim that a federal court in Massachusetts, ruled the arrangements. This would be the third country bilateral agreement he's talking about between the United States and third party countries. He's saying that the courts ruled the arrangement as unlawful. And I'm here to tell you that that is not true. And I will be bringing you the facts shortly. But before I let you hear what Mark Golding has to say, and please, I know some of you say you don't like to hear him, but please, you need to listen because it's the only way this video is going to make sense. All right? So listen to what he had to say. It's a short piece. So before I get into that, may I ask everyone, please, to give the video a thumbs up and to subscribe if you have not yet done so, and share. We need to get the information out to persons, especially those persons that don't understand, or them listening to the propaganda, or them believe what they want to believe that is not true. We have the facts, so we share the facts with other people. So I'd appreciate if you would do so, because me alone can't do it, right? Yes, great. And of course, feel free to leave your comments in the comments section. Thank you very much.
This matter of the third country nationals who are going to be coming to Jamaica pursuant to an MOU that we were told in Parliament yesterday by the Minister of National Security, Dr. Horace Chang, was signed by him, I believe, on behalf of the government of Jamaica last week, Thursday. Now, this is a matter which is of great concern to many Jamaicans. The U.S. courts have the lawfulness of these arrangements in their sights currently. There's a case decided by a federal judge in Massachusetts which said that these third country arrangements are not lawful under U.S. law. The government of the United States is appealing that to their Supreme Court. That matter is not yet resolved. But we are nevertheless embarking upon an arrangement, notwithstanding the fact that the lawfulness of that arrangement in the jurisdiction of the other country that we're signing to is itself very uncertain.
You heard him. You heard him, right? And this is the reason why whenever you hear people come talking to you about facts, what did he say? The fact that the lawfulness of that arrangement is itself very uncertain. Fact. And was it a fact? We shall soon find out. Now, Mark Golding proclaims himself as a big lawyer in Jamaica, commercial lawyer. And if this was what he read, court finds Trump administration's third country removal policy is unlawful, vacates the policy. If this was what he read and came to the conclusion that the court found the arrangements, the bilateral agreements between the US and third party countries pertaining to the deportation of non citizens are illegal, then he has obviously and clearly misled himself and in the process misleading the people. He's a lawyer. He's supposed to check the facts. Don't read and go by headlines, or you might miss the real story and get yourself in a problem. We're not going to the court documents themselves. What we're going to do is take the information from two sources. WGBH is a news media, and then we're going to take the information from the group that had actually brought the suit to the court in the first place. And this news item, as you can see, is dated 25th February 2026. And the report began by saying, a Boston federal district judge voided the Trump administration's policy of sending immigrants to third countries that are not their countries of origin, ruling it is unconstitutional. If that is all you read, right? Then you're going to come to the conclusion that the court ruled against the arrangement. But let us continue reading. The judge said it's not fine, nor is it legal. Judge Brian Murphy wrote in his 81-page ruling Wednesday. The class action lawsuit was brought by 4 plaintiffs, including 2 in Massachusetts, and covers detained immigrants. The order, which will likely be appealed by the Department of Homeland Security, says detained immigrants are entitled to meaningful notice and a chance to contest a third country deportation. You heard that? What did the court order? Having ruled that the way in which the Homeland Security was deporting these people from the United States was unconstitutional, the order that the judge made says that the people that them detain are entitled to meaningful notice and a chance to contest a third country deportation. That is what the judge is saying should have been the process. So Judge Murphy went on to say in his order, the government must first try to deport immigrants to their home countries. So it's not the arrangements between the United States and other countries that the judge was ruling against. The judge was ruling against the process, the internal process inside of the United States prior to them being deported. And what the judge is saying is, first of all, you must try and get these immigrants back to their home countries. That's the first thing. And then not talking about the asylum seekers, right? Because the asylum seekers that were refused is being afforded a humanitarian opportunity to go to another country rather than send them home, because usually without the agreement and they were refused the asylum because they didn't meet the threshold that the United States set, they would have just sent them back home. No, them send them to a third party country that may agree to accept them. If them don't find nobody, I guess them will have to go send them home. Remember, they were refused. Them don't believe that they are in fact asylum seekers. Them think them coming to the United States to seek opportunity, and I try to find a little backdoor way to do it. Right? So it's not that agreement the judge was talking about. It's talking about the ordinary citizens, the general persons who would have been deported because of the immigration violation, right? Overstaying of the country or then cross the border illegally. And them people the judge is talking about. And he's saying that the process that the Homeland Security is using to deport the persons, that is what is illegal, not the arrangement itself. You get it? And I will show you further why I say so. So from this news station, we're getting additional information. The Trump administration's policy has been in effect since last March, and that will be March 2025, allowing immigration officers to remove immigrants to third countries without giving them a chance to contest their removal. You heard that? Murphy issued a preliminary injunction last year that temporarily paused the policy, but it went back into effect last June. And of course, we want to thank the WGBH News people for bringing us that information. Now we're going to go to the group now that actually took the matter to the court. It's called Human Rights First, and they have an organization. This one was published the 26th of February 2026 this year. It says, court finds Trump administration's third country removal policy is unlawful, and they vacated the policy. Again, if you read the headline, you may be misled. You have to read what the judge actually ordered or they actually ruled in order to know what it was that the judge had actually said was unlawful. And their report began by saying, Boston, Massachusetts, the National Immigration Litigation Alliance, the Northwest Immigrant Rights Project, and Human Rights First welcome today's decision from the U.S. District Court for the District of Massachusetts declaring unlawful and setting aside the Department of Homeland Security third country removal policy. Question is why? Why did the judge rule it unlawful? Was it the arrangement that the United States signed between the countries and themselves, or was it something else? Let us read on. DHS, the Department of Homeland Security, has relied on the policy to send non citizens under final orders of removal to third countries, countries to which they were not ordered removed, without notice or opportunity to seek protection from persecution and torture. And here again, it is clear. It says without notice or opportunity to go to court and seek the court's protection from this deportation to a third party country that they believe they may be tortured and persecuted in. So the order is not about the deportation to third party countries. No, they're not challenging the deportation to third party countries at all. It is a process of the removal I'm talking about. The decision granted partial summary judgment in DVD versus DHS, a case in which the three organizations represent a nationwide class of individuals with certain final removal orders. So, when Mark Golding had said,
There's a case decided by a federal judge in Massachusetts which said that these third country arrangements are not lawful under US law.
not true, not true at all. This is the background now to the suit. It says at the time the case was filed in March 2025, the Department of Homeland Security had no policy to ensure due process protections or the ability to raise a fear based claim before being deported to any country other than the one identified in their removal proceedings. Following the district court's issuance of a temporary restraining order ensuring the process protections to certain class members, the Department of Homeland Security swiftly developed a third country removal policy. And it is this policy that is being challenged in the court, which the district court rejected and required more robust protections in a subsequent order. And so they said now, after the Supreme Court ultimately stayed the district court order on June 23, 2025, the Department of Homeland Security third country removal policy took effect. Since then, the Department of Homeland Security has been aggressively moving to deport non citizens under final orders of removal to any country that can be persuaded to take them. So, what is this saying? Now, remember, when the court case started, Homeland Security did not have a policy to deal with deportation to third party countries. They then developed a policy, and the policy was rejected by the court June 23, 2025. They appealed the decision of the court, the Supreme Court stayed the order, and Homeland Security implemented the policy. In February of 2026, the court in Massachusetts ruled that policy is not good enough and ruled it unconstitutional. So it is the policy of Homeland Security that was ruled as unconstitutional. So that is a long and short of what is going on in the United States pertaining to the detainees who are being deported out of the United States. And this now is a Donald Trump's policy that he created when he came to office. So there is no question the program is in jeopardy. But that is an internal matter for the United States government to solve. The question, though, of the legality of the arrangement between the US and the other countries, including Jamaica, to enter into this MOU was not the subject of the court matter that was brought and decided on in the Massachusetts court. And therefore, the arrangements were not unlawful, as Mark Golding falsely claimed. And that is what I wanted you to know. Mark Golding, not for the first time, not for the second time, but for the umpteenth time, was wrong. He brought you misinformation. And I hear him talking about the Minister of National Security should be referred to the Parliament's Privilege Committee for saying something that was not true. Well, if he had gone to the Parliament and made this pronouncement, I know he made some pronouncement about it in the Parliament, But if he went to the parliament and claimed that the Massachusetts court ruled that the arrangement is illegal, then he too should be referred to the parliament's privilege committee for misleading the parliament, since I saw him want to play the game. So before him attempt to move that motion, he better check very carefully what it was that he said in the parliament about the legality of the program. Well, folks, that's it for me today. Let me thank you for joining me, and let me know, please, if you find this video informative, if you got any information from it you never had before, and what you think about what Mark Golding said and what it is that the court decided. If you like the content and appreciate it, please remember to give the video a thumbs up, as well as share and subscribe to our channel. Until next time, take very good care of yourselves and walk good.